Good afternoon and welcome back. We have quite the treat for you today. We are stepping aside from the Jimmy Rogers case and we're jumping right into the Markeith Loyd case. Now, if you recall, he was found guilty. There were a number of outbursts, a number of great cross-examinations. At some point, he's trying to argue with the judge himself that he wants certain information in. As you can see here, we have the defendant, Markeith Loyd, in the clip there, but we also have the defendant, Terry Lenneman, in that clip as well. And we're actually joined by Terry today. Terry, how are you doing today?
I'm doing good, thank you.
Great. Now, Terry, I know it's hard to come back off of a case like that and have someone poke and prod and ask you a bunch of questions, but I appreciate you coming out here today for us. Just off the top, you heard the sentence. What are you thinking of what went down during the verdict in that case? How are you feeling after that verdict?
I feel really good. I think that the jury clearly made the right decision. And there's no question that from the beginning, we were looking for a jury that would make the right decision.
Okay. Now, in terms of, so a few questions here that definitely us here at the network want to know is, at one point he said he did not want to be there for the verdict. That he's like, hey, I'll waive that. And the judge even said, hey, if you get life or whatever it may be, we might just go right into sentencing. You might waive that as well. And he said, I don't need to be there. But he changed his mind in the last few moments. Is there anything that you can tell us as to what that change was or why he decided to be there?
Yeah, it had nothing to do with the verdict. You know, he really doesn't care about mitigation. I mean, his whole focus on this trial was the killing of Miss Dixon. And, you know, his belief that he defended himself. And so I think it had less to do with anything to do with the verdict, and it was really about, there was some discussion at some point that Miss Dixon's mother was going to come in and testify at the sentencing hearing, because it seemed like before we got the verdict, there was some feeling because of the way the jury came back pretty quickly, and, you know, the way things had gone through penalty phase, especially the last day and a half or so, that we were going to get a life verdict. I mean, that's what we were anticipating. And I think that was kind of the same sense within the court system. So they were already talking about sentencing him, you know, to life, because that's the only, you know, sentencing option that's available. And so he really didn't care. You know, he just wanted to go back. But when he found out that, you know, it was possible that Ms. Dixon's mother was going to testify, I think he wanted to be there.
Yeah, that makes a lot of sense. Now, as I said during the break, Terry, I'm a public defender here in New York. The work that you do, you're like the rock star of our profession. I tip my hat to you, sir. But I want to get your reaction as to what the sheriff had said last night, and I want to make sure I get the quote here. He said that the death, quote, the death penalty is made for cases like this. And he later on went to say, there's some satisfaction knowing he will never be a free man. What is your reaction to hearing someone say the death penalty is made for cases like this?
Well, I mean, you know, I think you got to take a hard look at the sheriff. The sheriff was the chief of police of the force that Ms. Clayton belonged to. So I am pretty confident he was a friend of hers. You know, directly, this was, you know, his officer. And from the very beginning, he was very vocal about wanting to kill Mr. Loyd. I mean, that has never changed with the sheriff. You know, he certainly has, you know, his right to an opinion like any other American on the death penalty. The problem is that there was a lot that you didn't hear about. And, you know, one of the things was that several of his officers brutally beat my client when he was arrested. And, you know, the 18th Judicial Circuit prosecutor who was appointed to investigate that did a thorough investigation and found that, you know, there was no use of force, or the use of force was justified. You know, it's outrageous. It was seen on helicopter footage where my client was on his stomach and they were beating him with a rifle. So, you know, this is the country we live in. You know, guess what? You know, this is the justice that the city of Orlando, Governor Scott, who was then the governor, the 18th Judicial Circuit State Attorney, Brad King, all these folks have turned a blind eye to this. And unfortunately, our country is complete with history of these kind of so-called lynchings. Whatever you want to say about the sheriff, he has a right to his opinion. He has a right to hate my client. He has a right to want him dead. But he also has a responsibility as a elected member that he's not only answering to the pro-death people, he's answering to the entire community. And there's a big part of that community. There was a prosecutor in this community who refused to chase down the death penalty in this case and got thrown off the case by Governor Scott, a Republican. I mean, there's all kinds of politics going on. And the death penalty is caught in the middle of this. And you know what? African Americans are too. And, you can call it what it is, but, the system is not fair and has never been fair. That's the bottom line. And so with the death penalty, do you want to kill people just discriminately? And, sometimes get a few people caught up along the way who shouldn't be killed, whether because they didn't do it, because they don't deserve it. And those folks don't care about that.
Yeah.
The ends justify the means. So that's where we're at with that.
Powerful words, and it's a sad reality that you're highlighting that we face in this country, and I would agree with you. Now let's take a bit of a turn. Now, you're preparing for another trial, right? And the question that I'm
preparing for a lot of trials.
A lot of trials. at least with Markeith Loyd, another trial for Markeith.
Yeah, in May.
Yeah. So the jury you select, you said that you found the right jury in terms of the decision that they came up with. Do you think that you're looking for the same type of juror in the second case to kind of have that similar thought process for this case? Or are you looking for a different type of juror?
As you know, in death penalty cases, there are the two polar extremes of jurors. There's the people who want to kill and automatically kill, and there are the people who are, will never vote for death penalty under any circumstances. And under Witherspoon, neither one of those are allowed. And then you have this kind of concentric core that starts to move in. And, so my focus is to try to find people who are in the middle of that community who, are going to be allowed on the jury because they believe that the death penalty would be appropriate in certain circumstances, but they're not going to be extreme in their position either way, so they become excludable under those circumstances. This is going to be a little more complicated because, when we were picking the jury, it took about 7 or 8 days, and we did individual voir dire. And the two main issues of individual voir dire was one, pretrial publicity involving the Clayton and this case. And there was about 70% of the community that knew about this when they talked about it. And a percentage of that, probably a larger percentage than you expect, had formed opinions that they couldn't get around. And so you're going to be stuck with that same situation here, but you also have all the publicity that took place in this trial now. And I think what's going to happen is I have seen, I came into this case without hesitation pointing the finger at the press because the press vilified my client from the very beginning. From the very beginning, they vilified him. And so I didn't hesitate to point my finger at the press for that. What I've seen is a softening press, I've seen a softening of the community. There are people in the courtroom that are law enforcement officers that were recognizing Markeith as a human being for the first time. They got to hear him, they got to see him, and even though he testified and, his testimony may have been rejected in part or whole by the jury, to see who this man is. And, this man, he loves his family, loves his granddaughter, he loves his children, This man has spent part of his life loving people and being loved. And so, it's so easy when we vilify people, and that's, if you go back to racism, the core of racism is that, the history behind racism is that we vilify people because this is the color of their skin, not about who's inside or who they are, because people are raised in an environment that's okay, and that they're taught that. And so that's no different still. That still exists. But in this particular case, he was vilified through false information from the press at the outstart because the police were not being honest about what information they had about her gun being in the middle of the yard. And my client, who's mentally ill already and has had to deal with those kind of things his entire life, the trust issue went out the door even more. And he became fearful that he was going to be killed by the police and so on and so on. And so you're going to see a lot more of that take place in the second trial. You learn more about those issues in the second trial than we did here. And there's a possibility I chose not to introduce the evidence of his beating. The judge had ruled that I would be allowed to introduce the evidence of his beating at the penalty phase as mitigation. But what essentially happens is that these officers who beat him concocted this whole convoluted story about how, they thought he was going to go out in a flame of, shots and, we were going to do this. And that's why we beat him. That was our justification. While he's laying on his stomach, surrounded by multiple cops, they were justified for beating him because of their state of mind. Even though they had rifles and, outnumbered him, 30-1. I mean, you can see him laying there. He's with his arms stretched.
So Terry,
they just come up and look and kick him right in the face.
Yeah.
Kick him right in the face, and then they move the camera. It's outrageous. It's outrageous what the governor, the prosecutors, the police, even the community and the press allowed in this case. It's outrageous, but it's not my show. That's not my job. My job is to defend him. And so at the time, my thought process is I felt really confident going in to this particular case that I didn't need to make an issue out of it, and I didn't want to draw all that rebuttal information that they're going to try to bring in if I bring that up in penalty phase.
Yeah, I know.
All the bull, that kind of thing. It's an evidentiary issue, and you have to make a decision on what the value of that is.
Yeah. Now, quickly, you alluded a little bit about the difference between this case and the upcoming case as to Markeith Loyd's mental health. Do you feel that there's going to be, because I've seen some articles you say that might play more of a factor in the second case in terms of a defense than it did in the first case, his mental health?
I don't know if you saw Marvin Dunn. Marvin Dunn was a fabulous witness, African-American, 80-year-old social psychologist. I wrote a book on the riots in Miami in the 80s. He was one of our experts, and I'm going to be looking for some more experts on this issue. But, the interesting thing that really didn't play out in this case is that, there are 33,000 pages of Facebook material that was obtained from Markeith's Facebook page at the time that the feds executed a warrant after he killed Miss Dixon. And there is a lot of really important information about his state of mind in those documents. And so I think that that's going to play a deeper, because essentially he gets out of prison in 2014. And so between 2014 and his arrest in 2016, he becomes an avid Facebooker. And he's ranting about racism and mistreatment and mistrust, and there's significant evidence of paranoia. And I didn't get into all of that because it wasn't necessary for this case, but it may be necessary for the next case.
I like it. Well, it's my understanding, Terry, we got to let you go, but I do want to finish on this. Like I said, you're the rock star of our professions. I went to school with Professor David Bruck and Judy Clark, who do a similar practice, and I was always taught that the State of the Union can be measured by how we treat our lowest in our communities who are faced with some of the most heinous crimes. And I think with defense attorneys like you, I think the State of the Union is in pretty good hands. So thank you for your work. Keep fighting the good fight, and thank you for coming on with us today.
I appreciate it. Thank you, too.
Yeah, not a problem. Have a good one. So we're going to continue more with some of the most hard-hitting and biggest cases we've got here in the United States. We got to come back for more of the Law&Crime Trial Network.